Todd, do you have any water there? It's a challenge to know how to open it.
I'm sorry, yes. May it please the court, my name is Owen Todd, and I represent Robert Norton, who has been an attorney since 1953, 54 years, and I represent Francis Harney, who has been an attorney for 41 years. Neither of these lawyers specialize in handling trusts. They have a general practice, which did include some probate work. And these lawyers are attorneys who, during that period of time, have had a spotless record before the bar. Yet a probate court judge has branded these men as attorneys who have committed fraud in the court. The cases I have read have characterized fraud in the court as conduct akin to bribing judges, fixing juries, suborning perjury, producing false witnesses. This court has described fraud in the court as the most egregious conduct involving a corruption of the judicial process itself. Contrast this type of conduct with what the probate court judge charged as fraud in the court.
But Mr. Todd, I understand you're concerned about that, but certainly the probate court didn't have to find fraud on the court in order to remove your clients as trustees. That's not the standard.
I believe that the judge below thought he did have to find fraud in order to remove these gentlemen from their position as trustees. And I believe that's why he did.
Where does the burden of proof lie in this case?
I have the burden of proof.
You have the burden, okay.
I must demonstrate that they conducted themselves appropriately and that they conducted no acts which justified their being removed as trustees.
Well, Mr. Todd, you've set yourself, maybe a high burden, but to say they acted appropriately, are you suggesting that by paying the fees for the multiple number of trusts out of the major trust was appropriate?
Your Honor, I maintain it was appropriate. It was testified to be appropriate. It was a decision that was made decades ago by the accountant who produced these probate accounts, that it made sense to allocate some of the trustees' fees to the agricultural trust. Now, the judge below made a mistake when he said all of the fees of the trustees were allocated. They were not. Only the monthly fee.
The bulk of them. Just the monthly fee, but that was, in fact, the bulk of the fees.
The bulk of the fees. And the decision was made by the accountant to do that, and by various trustees through the years to follow that suggestion, and the courts to approve it, on the basis that most of the assets were with the agricultural trust. Most of the time and attention was spent dealing with the grant-making and gift and loans that were required in the agricultural trust, and that the agricultural trust was most able to pay these fees.
Putting aside this fraud on the court, it's understandable why these lawyers would be upset about that finding. But if we take that away, if we say, the judge shouldn't have done it or the law doesn't permit it, do they still object to being removed as trustees?
Do they object?
Yeah.
Yes, they object.
They still do, so they're appealing the removal as well.
Yes, we ask that the court...
They want to be back as trustees.
They would like to be back as trustees. This is something they've spent years and years doing. They've been good and faithful trustees. They've increased the burnt corpus 70% in their years.
On that point, weren't they supposed to distribute all the income of this trust to, I think it was students in the forms of loans and grants and so forth? But they end up putting it instead in some kind of endowment? Isn't that clearly contrary to the express language of the trust?
They distributed more than all of the income in the agricultural trust. The court will see from the records that in '99 they distributed more income, more money to the farmers and loans and to UMass's grants and scholarships and so forth than the income that was produced. They did that in the first 6 months of 2000, spending down the accumulated income.
There were sizable payments to the endowment, and the endowment deliberately reserves 10% of the income year after year after year.
in order to build up.
Maybe a wonderful idea, but it's not what the terms of Crabtree's will provided.
I believe it is, Your Honor. And reasonable minds can differ, and if you believe that, then reasonable minds do differ. If you look at the will, you will see that it says the money that isn't used for farm loans will be used to assist needy and meritorious students in completing their courses of study in UMass. That's what the endowment does. That's what the 4 witnesses from UMass said it did nobly and spectacularly. Judge Priest in 1940 said, the trustees may in their discretion expend income to assist, whether by gift or otherwise, needy and meritorious students. They have assisted otherwise in the endowment. Judge Wilson, 1971, in any event, the trustee shall have full discretion to determine the students to be assisted and the amount and nature of the assistance to be given to each.
Was there one trial here? On this, was there one trial here on the 7 accounts, or had the first 6 already been approved?
In 1999, 6 of the 7 were approved.
And this was just
and
on
there
the
was questions on the agricultural.
Well, then, wasn't it up to the trustees to have, weren't they obligated earlier to bring it to the attention of the court how they allocated the agricultural funds money?
You mean it's between the endowment and the scholarships?
No, it's between, they claimed that they took all their expenses out, or most of their expenses out of one fund, one trust.
Oh, no, the expenses are paid initially by the agricultural trust checking account, but they're all reimbursed.
Right, but since the other 6 trusts had already been approved, the accounts for the other 6, shouldn't they have alerted the judge to this procedure earlier? During the allowance of the other 6?
Well, this procedure's been going on for at least 35 years.
Mr. Todd, you've said that a couple of times, and let me just say, ask you to respond. 1, it really doesn't matter what an accountant recommends. An accountant is not the fiduciary. 2, it really doesn't matter what a prior trustee says, because when you become a trustee, you have to work out what your obligations are. 3, I thought it was settled law that when you are a trustee of account A with and account B and account C, that you can't move monies between those accounts unless the donors, let's assume there are 3 different donors, so that you've got Giacomo, Todd, and Marshall. We set up 3 separate accounts. You couldn't possibly be taking all of the fees to run the Giacomo and Todd accounts out of the Marshall account. And I don't know that there's any law that says because the donor sets up 3 different accounts, it's the same donor, that you can mix and match in that way. So why isn't that conclusion of the trial judge, which is conclusion number 3, a breach of fiduciary duty?
Judge, there was a good reason to do it that way. As I indicated, the agricultural trust involved much more time than the other trusts. And some of the charge...
But that's like saying, to administer your trust, the Todd trust, doesn't take much to administer. The Marshall trust takes a lot of time, so I'm just going to charge the Marshall trust for all of my time. You can't do that as a trustee, can you?
Well,
I mean, isn't that what the judge is saying?
it was an error of judgment at the worst, Judge, and what I suggest is the probate court should have said, now look, I think it's much better, much cleaner, much more in keeping with how we'd like accounts kept, to do it this way. Try to apportion it as best you can, and we'll deal with that going forward. But I don't think there's a breach of fiduciary duty that warrants them being thrown out in a disgraceful fashion.
Underlying the trial judge's order, it seems to me, is he makes a conclusion that it's a breach of fiduciary duty. For whatever reason, the donor chose to set up different funds, and the donor chose to put different amounts of money into different funds. And it's the obligation on the trustee to respect the donor's intent. Now, if your client say, well, we're really not experts in this, and we really follow the advice of the accountants, and, well, people have been done it for years, why wouldn't a trial judge say, these are really not people who should be in charge of administering these substantial trusts. And they're doing it in a way which isn't just better judgment, just it's not in compliance with what a trustee should do.
He can arrive at that conclusion. I believe they acted reasonably when they said, we get advice from a probate accountant. Other trustees over the years have been doing this way. It has been approved by the court this way. It makes sense when you try to allocate this thing, how difficult it is to impose the largest burden on the trust that can afford it and takes the most time. It was a reason. But if it's a mistaken judgment, I believe it can be undone without removal.
I have a numerical question. Your affidavit says that $3,500 a month plus $1,000 a quarter was charged to the agricultural fund for 1999. My arithmetic, which isn't very good admittedly, makes that come out to be about $46,000 for the year. But there was a total charge of $149,000 for 1999.
Three trustees.
Three trustees.
Oh, that's okay. All right, thank you. Then one other question. If the grant-making time was included in, I'm asking you, was the grant-making time included in the time spent listed on their affidavit? Grant-making time, the time?
The grant-making time is, yes.
That's
That's
included.
included in their affidavit.
Okay.
But in finding, as the probate court judge did, that their fees were excessive and surcharging them to the extent he did, which amounted to $123,000 out of $149,000, leaving them $5,000, the three of them, for all of this work, and resulting in a surcharge of an amount greater than either Mr. Norton or Mr. Harney received as fees. They're going to have to dig in pocket to pay this surcharge.
Was the surcharge a combination, did the surcharge also include this sort of office expense?
Yes.
All right.
What he did was, in arriving at a fee, he arrived at some minimal amount of money, all based on error, and then he said, I'm going to take from that all of these expenses that they should have paid themselves.
Right.
But couldn't that be paid back to them if the accounts on the other trusts were reopened?
I suppose if we wanted to do that, but they
really.
could what be paid back?
The amount that they were required to disgorge?
Oh, I don't know.
I don't think so. I mean, it may be, perhaps some of it. For instance, if the 1999 accounts were open for the 6 trusts that had been closed and additional fees had been assessed to those trusts, but I don't think that would resolve in negating this
No,
this
but
surcharge by any means.
no, it wouldn't.
No.
But in finding that the fees were excessive, the judge made a terrible mistake. He started off agreeing with the experts that we produced that, yes, there should be a fee for managing the money, for taking the responsibility for investment decisions and so forth, and that he based on schedules of banks and large firms that we produced. But what the mistake is, that he took all of the assets of the 7 trusts, aggregated them, and then treated that as one trust in order to compute a fee, when indeed all 7 trusts should have been applied to the schedule. And had that happened, instead of $41,000, the fees justified by the schedule would be $85,000. Then he ignored entirely what appears on the schedule as a 6, 7, 8% income earned fee. He didn't calculate
You had treated
that.
the trust as essentially, one.
Negative.
Well, yes, because what I was talking with you about before, that they took all their expenses from one trust and then paid them back at the end, pay the individual trust back at the end of the year.
They used an operating account, a checking account, but when they were going over these trusts, deciding whether to buy or to sell or to hold or to whatever, the testimony from Mr. Morton, the investment advisor with Smith Barney, and from Mr. Harney, was that we treated each trust separately. We looked at all the investments separately. We made decisions separately. Indeed, the exhibits of Mr. Harney's spreadsheet show notations for each separate trust, sell this, hold that, so forth. So he treated, as did Mr. Moran and the accountants, each trust separately, as would any bank or law firm in deciding that. Then, when they came to the grant-making portion of their fee, The judge made the mistake of saying, how much time is involved? The testimony was, we don't keep time. Mr. Puzo, who was a huge trustee in the city, said, trustees don't keep time. Grant-making is calculated on the basis of the difficulty that's involved. Boston Foundation charged 1.5% of the assets, and that would be $130,000 fee at 1.5%.
Are there significant recent cases about whether fees are based on a percent of the assets or on time spent?
There's a case that I think this court decided that said that fees should not be blindly based on percentages alone.
Is that a recent case or an old case?
I think that case might be 5 or 6 years
Oh.
old. I'll send it up if you want.
Thank you.
Thank you, Mr. Todd.
Am I out of time?
You are out of time. You are over time.
I just want, may I make one small little point? The
In-
trustee, the GAL rather, is constantly with this cant that the fee is 63% of the income earned. The fees were 6% of the income earned. And what mistake the GAL is doing is he's taking just the income earned in the agricultural fund, not all 7 trusts. Then he takes the portion of the fees that's dedicated to maintaining the principal, and he lumps that in to come up with this false 63%. I just wanted to make that point. Last, I just wanted to cite a section if I could.
That's fine. If it's in your brief, or
It
you
isn't
can
in my
submit,
brief.
you can
I
submit a
never wanted
letter. Submit it.
Thank you.
Thank you. Mr. DiGiacomo?
May it please, I'm sorry, may it please the court, as you know from reading the record, after 14 days of trial, the trial judge made specific findings of fact. I think they numbered over 271. He gave a rationale for his decision. He gave conclusions of law, and he attached an addendum for his calculations. And clearly, his subsidiary findings are supported by the evidence as well as his
Did he
findings.
rely heavily on this fraud on the court
There-
conclusion?
He did make a specific finding that with respect to the payment by the trustees from the agricultural trust
To the
of
endowment.
fees for services for other trusts, that was a fraud in the court. And I will say, Your Honor, that I took the position that it was a fraud in the court. The appeals court in their footnote 4 is incorrect. My opening statement, I indicated to the court that the actions of these trustees was a fraud on the court.
Could you explain that to me? Why is it a fraud on the court?
Yes, I will explain it to you, Your Honor. The trustees, officers of the court, their attorneys, submit an account, 2 accounts to the court, sworn to under the pains and penalties of perjury, that what they are furnishing to the court is just and accurate. That's false. And as I say, as officers of the court and professional trustees, as classified by their
I'm
own...
trying to explain, I'm trying to understand the
All right,
false...
now I
Did they-
will.
Okay,
I will.
'cause did they say...
And
Go ahead.
there are 2 classes of cases that discuss fraud in the court. One is classes of cases which relate to a vacating of a judgment, usually under Rule 60B. Then there is another line of cases which relate to probate accounts. And that line of cases found its origin in the National Academy of Sciences against Cambridge Trust Company. And that is cited at 370 Mass. 303. And that line of cases, which has recently been cited by the appeals court in the DeLuca case, and that line of cases hold this, Your Honor, that where a probate account either is inaccurate because of misrepresentation or otherwise, that there is at least a constructive fraud or a technical fraud which would permit the court to open the accounts that have been allowed. That's why it is important in this case. In this case, the account before the court was the account for the Agricultural Trust for 1999 and all 7 trusts for the 6 months of the year 2000. A fraud has been committed by making these payments from the Agricultural Trust by excess fees that the court has found for years.
All right, can I ask you that question? I mean, I find it, if in fact they have accurately reported their fees, I find it a little hard to believe that this is a true fraud on the court. They have accurately reported their fees, correct?
Pardon me, Your Honor?
They have accurately reported the fees.
But they have never disclosed the basis. That's the problem.
Well, they've never been asked to disclose the basis.
Right.
Have they ever been asked to disclose the basis
Yes.
other than in this proceeding?
In this proceeding,
I know they were in this proceeding.
audited by the court. They refused to as a matter of fact, the matter was before this court.
Mr. DeJohn.
And they were required by affidavit, and for the first time,
Okay.
they accurately reported to the court what was going on. Yes, Your Honor.
Mr. DiGiacomo, I'm looking at the judge's findings of fact with respect to the 1999 accounting, which I think begin in or around number 229. Is part of the claim here that in payments from that were taken from the agricultural fund in that year, forget about other years, to, as it were, for trustee fees for all the other accounts are not reflected in that submission to the court?
That is correct. They did not,
So
in that particular account, disclose
that they had
those
taken money out of the agricultural fund account to pay fees for some other account.
That is correct.
Second of all, I take it that another claim is that in saying, and I'm looking at the judge's findings of fact, not the underlying documentation.
What page,
that
Chief?
This is on page, Record Appendix 68, that the disbursements reflect that these are, quote, farm loans and grants to students. A reader of that submission to the court would not unreasonably conclude that these were trustees that were making grants to particular students and not paying it to an endowment fund. Or is that not the case because of the addition to the endowment fund at the university?
I'll see if I understand, Your Honor.
I'm trying to figure out the specific of what the
Right.
of what the failure to accurately reflect
Right.
in this
In
account
the,
was.
in the 1999 account,
Right.
there was a payment to the University of Massachusetts for $75,000. That's what it said. Now, in reality, there were 2 payments. One payment to the University of Massachusetts for $50,000 and one payment to the University of Massachusetts Foundation for $25,000. That was not disclosed.
Okay, so in fact what they did disclose was $50,000 as a grant to students, which if you looked at the Crabtree
Correct.
Trust, you'd assume that I had given it, that I, the trustee, had made an assessment and decided to give it to A, B, and C student, not to the University of Massachusetts.
correct.
Okay. Could I ask you another question?
Yes, Your Honor.
With respect to the 1971 court order amendment to the trust, I take it, although I again haven't looked at the full record, that this was in response to the amendments in 1969 to the internal to the tax
In
code.
part, you're correct, Your Honor.
Okay. And I take it that part of what the trustees were trying to accomplish was that they would comply with the required minimum distribution. And if not, there are substantial penalties if you don't do the minimum distribution, correct?
Right.
So that was the genesis. In addition to that, there was an attempt to go from grant to loan and also to expand the category of beneficiaries in order.
Well, they did expand the
Help me out.
right. Initially, the beneficiaries were limited solely to the School of Agriculture.
Okay.
Then it was expanded to include the Stockbridge School, which is
Right.
Affiliated. And then it further expanded the beneficiaries to any students within the University of
And
Massachusetts.
I take it that part of that was because the Internal Revenue Code requirements had changed, obligating trustees to make distributions, and I infer from this that the category of needy students in the agricultural school were too small in number.
That is
that you-
a reasonable assumption.
That you
I don't-
either had to give non-needy students in agriculture, or you had to give needy
Right.
students in non-agriculture. And the trustees sought and the court ordered that they could give to
These were by court decrees, these expansion of
the category.
beneficiaries.
Yes.
And he read to us, Mr. Todd read to us, certain language in the decrees that seemed to permit them to do what they did, like the words "or otherwise," for example.
No, that related to the determination of the students who were to be benefited,
Okay.
not to change the terms of the will.
Not to
If
allow
I,
the
if I
endowment.
might, I do want to return to the fraud in the court and point out to the court why it is significant. If there is a finding of fraud in the court, prior accounts may be reopened, and at that point, appropriate adjustments made. If there is not a finding of fraud on the court, then prior accounts may not be reopened. And the problem that I have as guardian ad litem is that since 1984, when one of the trustees was appointed, they have paid from the they have paid trustees' fees for all trust of somewhere in the vicinity of $1.5 million. They've received that amount of money. At least half of those fees came from the agricultural trust, and they shouldn't have come from the trust. There's no authority to do that. The student beneficiaries have been harmed by that action. And
Well,
as a
if only
result,
if only half of them came from the trust, the agricultural trust has got about 60% of the assets. Why is that a problem?
well, it could be 60% of the assets. I don't know. I haven't calculated it out. But even if that percentage, the point that I'm trying to make is that there are hundreds and hundreds of thousands of dollars that have been improperly paid from the agricultural trust when those funds should have been for the benefit of potential students. They cannot be recovered. They cannot be recovered in this proceeding unless there is a finding of fraud in the court.
Thank you. Now I understand why that was an important finding. It really has nothing to do, it's not necessary to whether they should be removed or not.
Absolutely not, Your Honor. There's a litany of findings on removal that would substantiate that
Let me
basis.
see if I understand this endowment better. It
Yes.
seems to me that what they did is they basically agreed with UMass to set up, in essence, another trust.
Correct.
And the monies from the agricultural fund that went to UMass would largely go into this endowment fund, which really is a sort of a trust in and of itself.
Correct.
And only the interest from that trust, and not all the interest, would be used for scholarships/loans for students. Am I correct about that?
You are absolutely correct. And that amounted to about $630,000, which the trustees paid to the foundation. We do not criticize, and nor have I ever, the foundation and the way it has conducted itself.
You just have to get a court order
But that's
to do
not
it.
what Donor wants.
You have to get a court order to do it.
Absolutely. And they never, on any occasion, sought guidance from the court. I'm sorry.
To interrupt you. Speaking of fees while we're on it, I noticed the appeals court said they weren't going to deal with your request for compensation in connection with the appeal to the appeals court. They were going to send that back to the trial
Right.
court.
And I'm asking this court,
You don't like that, do you?
I certainly don't.
Because how's the trial court going to gauge your work on appeal, for one thing? And secondly, if you prevail, it seems you're entitled to appellate fees as well as whatever else. Your
I've
trial
been
fees
I've been
and so on.
involved in this case now, coming on 7 years, and haven't received any fees from any source.
The guardian ad litem
whatsoever.
fees must be fairly significant, aren't they?
They certainly are at this point.
You've submitted bills.
I've submitted requests for fees to the court, but the case hasn't come to an end yet, So we're
Did you
waiting for that.
In your brief, did you request fees?
Yes, I did, in accordance with the procedures set forth by this court, I
Out
did
of
request.
general figure, what would the general figure for all the fees be for the guardian ad litem?
I had,
Including both appeals?
right, Your Honor. I believe, and I should have looked at this, I believe that I had charged $250 an hour for my work and have never adjusted that from the year 2001 when I was appointed to the present. And I considered the fact that this is a charitable trust and therefore reduced that amount of money. I would expect that the fees and the work, this is 2 appeals before this court, I would expect that they would be $250,000 at this point.
And that includes the trial work.
The trial appeals, single justice appeals, I would anticipate that they are
Okay,
in
that's all right.
in that range. And out-of-pocket disbursements, I don't know
Yeah.
what they are at this point. Your Honor, the other points are addressed in my brief. And I'm asking the court to affirm the trial judge's findings and to finally bring this matter to a conclusion. The judge entered 8 separate judgments in connection with this matter. The judgments clearly indicate that the trust now is being properly run without space outside of its facilities by 2 appointed trustees. And by the way, the trustees themselves, and they filed their account in the year 2001, reduced their fees from the agricultural trust, indicating that henceforth they were going to properly conduct themselves. They breached their fiduciary duties, they should be removed, and the surcharges are proper.
Thank you, Mr. Giacomo. Thank you.